We are now on to Chapter 4, the Rule of Law. In this chapter, we will learn procedurally and substantively criminal law and just the basics. We saved the detailed information for criminal law class. This is an introduction class, so we go over just the basics. And just the basics of the information that you need to know. First thing we need to understand is that there are two types of law in our jurisprudence system in this country. We have criminal law and we have civil law. This is a criminal justice class, so we will focus mostly on criminal law. However, we will get into a little bit of civil law. And the first thing I want to do is go over what the differences are between criminal law and civil law. First, criminal law, when there is a violation or a wrong on criminal law, we call that a crime. It's a wrong against society. No matter how personal a crime is, the quote unquote victim of a crime is society. A crime as personal as sexual assault. The true victim is society. And that's because it is a breach of peace that affects society as a whole. So criminal law, it's a wrong against society. It's prosecuted by the government, and it's driven by punishment. And that punishment is incarceration, sometimes death, and even monetary fines. And in order to convict somebody of a crime, the prosecution must prove the case by the standard of beyond a reasonable doubt, which is our highest standard in our jurisprudence system, beyond a reasonable doubt. It's not 100%, it's just under 100%. So it's a very high standard. Now let's take a look at the criminal law side. A wrong in civil law is called a tort. And that is a wrong against an individual. Unlike criminal law, where the victim is society, the victim under civil law is the actual individual. So you could have one act qualify as both a crime and a tort. For example, punching somebody. If you are punched by somebody, that person has committed the crime of battery, and they've also committed a tort against you. That person can be convicted of a crime, and you can also bring a civil suit against that person for any damages that you suffered as a result of that battery. On the criminal law side, you are not the victim, society is the victim, but in civil law, you would be the victim. And it's prosecuted by the individual called the plaintiff. So when you bring suit against that person for assaulting and battering you, you are called the plaintiff and you prosecute it. The government does not get involved. It is not prosecuted by the government. And the goal on the civil side is to make whole, and it's usually monetary. So if you are the victim of a battery and you suffered doctor bills or you lost wages because of work, the suit that you bring against that person would ask for damages to cover whatever that battery cost you. So when you were battered, if it cost you $5,000 in lost wages and doctor's bills, then you would sue for $5,000. And the goal on the civil side is to make that person whole again. And that's usually done monetarily through money. On the civil side, it's a lower standard of proof. It's what we call preponderance of the evidence, which is a pretty low standard. Preponderance of the evidence means 51% of the evidence. Whoever has the most evidence wins. On the criminal law side, the prosecution must prove beyond a reasonable doubt, very high standard. On the civil law side, the plaintiff just must show by preponderance of the evidence the defendant committed that act. So in theory, that person that battered you could be found not guilty of the crime because the prosecution failed to show beyond a reasonable doubt that they committed that crime. However, you could still win on the civil law side with the same exact evidence because the standard of proof on the civil side is much lower, and it's much easier for a plaintiff to win than it is for the prosecution to win a case because the standard is so low. So those are some of the differences between criminal law and civil law. We're going to focus in now on criminal law. And let's take a look at the origins of criminal law. Where did it come from? And the first written laws that we know about were created about 5,000 years ago in a place called Mesopotamia. And those are the first written laws that we know about. And then later on, we discovered the Code of Hammurabi, and that was from King Hammurabi. And this was a more extensive set of laws than the ones that we found in Mesopotamia. So these laws, or the Code of Hammurabi, were a pretty extensive set of laws. There were 282 laws under this code. And they were laws on marriage, divorce, debt, wages, slavery, and it also defined criminal acts. So early on, many laws were not just criminal laws, they were laws on everything that we deal with in society. And this was true when we found the Code of Hammurabi. It was laws on all different subjects, including criminal acts. And today, in this country, many of our laws are founded on what we call common law. This is an important term that I want you to know. What is common law? Common law are precedents from England that became law. And they're mostly created by judicial opinion. And what does that mean? That means that before England had laws written down, people would take other people to court and claim that what they did to them was the wrong. Or the government would take somebody to court and claim that what they did was a wrong to society. And then the court, the judge would decide if it was a wrong or not. And that is how the common law was created. And the church played a major role. The church was a big influence in England, and it was also a big influence in this country. So many of the common laws that were in England were really religiously based. And that's why you see a lot of these laws today, and if they may sound religiously based, It's because of the role that the church played in both England and here in this country when we were just colonies. And we do come from England. There were 13 colonies, and we were under England rule before we became our own country after the Revolutionary War. And the colonies, because we came from England, we adapted the common law. Whatever the common laws were in England, they followed the colonists over here, and the colonies just adapted them and followed them. And for many years, we operated under the system of common law. So the definition of common law is the body of law derived from judicial decisions rather than legislative enactment. Because that's the system we have today, is legislative enactment. We have moved away from common law and turned to legislative enactment in order to pass laws. We no longer rely on judicial common law to create laws for us. In fact, the system we have today, judges cannot create law. We still follow common law in many aspects, but we don't create new common law when it comes to creating new crimes. So laws today in the United States, under our system, our Constitution, the US Constitution, gives Congress the power to make federal laws. It's written right there in the Constitution, is that Congress shall have the power to make laws. Of course, Congress is a federal branch, so they can only pass federal laws. In other words, Congress can't pass a law making something illegal just in Massachusetts. When they pass laws, they're federal laws that affect every country. The state constitutions give the states the power to make state laws. Every state has their own constitution that is virtually identical to the US Constitution. The US Constitution oversees and guides federal issues and federal laws. State constitutions are where the states have the power to make state laws. And what most states did, in fact, probably every state, is they took these common laws that we got from England, and instead of just following common law, we created statutes for them. For example, murder. Murder was a common law in England, and it was a common law here in the colonies. As we began to advance as a society and we started creating laws through legislation, we just took the common law of murder and we wrote it down. We created a statute for murder, as we did with many, many other common laws. So many of our laws today were actually common laws at one time that we just codified. We just made them statutes. That's what we call codifying. We took these common laws, and instead of having them out there floating in air, we wrote them down. We codified them to make them legislative laws. And as we evolve as a society, we grow as a society, our morals change, our ethics change, and what we see, how we see things today, we may see them differently than how we saw them many years ago. And because of that, we have tweaked some of the common laws and made them fit for today's society. In addition, because we are an ever-changing society and because of technology, And sometimes because of things that just happen just naturally in our society, we need to create laws because there was no common law to address it. So we had to create laws. So many of our laws today were not common laws, were not common laws or any type of laws back when we were just 13 colonies and early on when we became a country. Later on, as we began to evolve, we found the need to start creating new laws to address certain things in our changing society. For example, carjacking. This is a little more recent one. Carjacking carjacking started in the mid 90s. Very violent crime, and in the mid 90s in Detroit, carjacking started, and it really was started nationwide. It was an epidemic at one point, carjackings. And we didn't have a law against carjacking, believe it or not. When someone committed a carjacking, we just charged them with robbery. But because carjackings were particularly violent, we found the need to create a law against carjacking. We didn't want to just charge them with robbery. We wanted to create a special law with an enhanced punishment because of the dangers of carjacking. So that's one example of how, as a society, we created a law to meet a need. A law that was an act that was not a crime prior to us creating that law. Another example, and this has to do with technology, is all these things that we've discovered in this age of technology, in particular cybercrime. Now, back in the 17 and 1800s, there were no common laws against cybercrimes because we didn't have computers. Now that we have computers and the internet and all this technology, we found people were doing certain things that we wanted to prohibit. For example, we didn't want to allow people to go into somebody else's computer and to look at their information on their computer. So we created a crime against that. We created all these cyber crimes that were not common laws because we didn't have technology the way we do now back in the 1700s. So quite often, what we're seeing today is we're creating laws to address needs in our society. There's two types of criminal law that we're going to discuss. The first is what we call substantive law. And substantive law is really pretty easy. It's just the laws that we create. It's the laws that prohibit conduct. A law that says you cannot drive while intoxicated. That's a substantive law. All laws are just what's written down that prohibits our conduct. That's what substantive law is. It's the substance of the law. The second type of criminal law is what we call procedural law. And procedural law governs the way in which the laws are administered. And when you take CRJ 258, criminal procedure, what that class is really all about is procedural constitutional law. In procedural law, it tells or it guides the government on how they shall enforce the law. So substantive law is the law itself that's created, and procedural law is how the government enforces that law. It's the process the government uses in enforcing laws. This procedural law is called due process law. And in a word, due process really means fair or fairness. So in other words, due process or procedural law means that the government must act fairly when they are enforcing substantive law. So it's the procedures that they use. Some procedures include when you are tried for a crime, that you have the right to a jury trial, you have the right to cross-examine witnesses, you have the right to have an attorney. Those are all procedures that the government must follow in order to fairly ensure that they are enforcing substantive law properly. So procedural law or due process of law is fairness. It's how the government enforces the laws, and they must do so fairly. So let's take a closer look at procedural laws, and it's the rights of the accused. And in our Constitution, after we wrote our Constitution, some years later, we decided to add amendments to the Constitution. So everybody's heard of the First Amendment, Second Amendment, Fourth Amendment, and that's what the amendments are. They're additions to the Constitution. And after we wrote the Constitution, we added 10 amendments. Sometimes people say 8, the first 8 amendments are the Bill of Rights. Other people say it's the first 10 amendments. For us, it really doesn't matter whether it's the first 8 or the first 10 amendments. But that's what the Bill of Rights are. It's the first 10 amendments at most of the Constitution. And these 10 amendments provide individual protections for us, protections against the government. We created the Constitution, and in fact, we revolted against England because we did not want to have a central or federal government that was too powerful. And part of the Constitution was designed so that government would not have too much power over us. And one of the things we added to ensure that the government would not have too much power over us were the Bill of Rights, these first 10 amendments, because these first 10 amendments provide individual protections for us. So this is just an example of some of the Bill of Rights and some of the procedural protections that we have. So under the Fourth Amendment, it tells us that the government cannot unreasonably search or seize us. Under the Sixth Amendment, procedurally, we have the right to a speedy and public trial, and so forth. So these are just some of the rights that the Bill of Rights provide for us to protect us from the government. And originally, the Bill of Rights did not apply to the states, meaning that the federal government had to abide by the Bill of Rights, meaning we were protected from unreasonable seizures under the Fourth Amendment from the federal government. But it didn't protect us from the state governments. And that was a problem. So we added the 14th Amendment. And through the 14th Amendment, now the Bill of Rights applied to the states. So up until the 1960s, the Bill of Rights only applied to the federal government, meaning the state government did not have to follow all those procedures that were in the US Constitution. And then in the 1960s, the US Supreme Court ruled that under the 14th Amendment, the Bill of Rights does apply. because the 14th Amendment states that no state shall deprive anybody of life, liberty, or property without due process of law. And the U.S. Supreme Court interpreted that to mean that the Bill of Rights also applies to the states. So after the 1960s, we now have protection of the Bill of Rights from both the federal government and the state government. So why do we have the Bill of Rights? As I stated before, is we fought for our freedom from England in the Revolutionary War. And England treated the colonies very poorly. There was taxation without representation. They were seizing us. They were searching us and our houses and our belongings without warrants. To finally, we got to the point where we decided to revolt. And we decided to declare our own independence through the Declaration of Independence. And England said, no, we're not going to allow you to become your own country. And that we said, well, then we're going to take you to war. And we went to war with England to earn our own independence and become our own country. And we won the war, obviously. We won the Revolutionary War. And after the war, we had to create our own government. Now that we're a country, we need a government. But because of what we just went through with England, we didn't want our new government that we just formed, we didn't want it to be too powerful. We wanted it just to give it just enough power to function properly and not to have too much say and control and power over us. And that's why we created the Constitution, and that's why we created the Bill of Rights, to protect us from our government, to make sure that this new government that we formed would never have the power to treat citizens the way England treated us when we were colonies. And that is a short history lesson on why we have the Bill of Rights, why we have the freedom of speech, why we have the Second Amendment, the right to bear arms, why we have the Fourth Amendment, the right or the protection from unreasonable seizures from the government. That this is, in short, is why we have these rights. And never forget what was sacrificed for us to have the government that we have today. And clearly what was sacrificed were the lives of many people who fought, lost their lives, lost loved ones, brothers, fathers, loved ones who gave their lives so that we could create this new country with this new government that was not going to be too powerful over its citizens. And now we're going to get into some of these amendments, some of these Bill of Rights, these personal protections individually. And the first thing we're going to look at is the Fourth Amendment. And again, when you take CRJ 258, criminal procedure, we spend a great deal of time on the Fourth Amendment. And the Fourth Amendment is really all about when the government can search us, when the government can seize us, and what protections do we have from the government when it comes to searching and seizing us. When can the police search our car? When can the police search our houses? When can the police pat us down? That's what we really get into when you take criminal procedure. But for this class, because it's an introduction class, we're just going to skim the surface of it. So what does the Fourth Amendment protect? It protects citizens from unreasonable searches and seizures. And really what that is saying is that the government or the police can only search or seize us or our property when it's reasonable. It doesn't say they can never search us. It just says if they are going to search us, they can only do so when it's reasonable. So therefore, The general rule is that every search and seizure must be reasonable. If it's not reasonable, it violates our Fourth Amendment rights. So if the government searches you and it was an unreasonable search, they have violated your Fourth Amendment right. If they search you and it was reasonable, they have not violated your Fourth Amendment rights. In order to be reasonable, most searches and seizures require a warrant. Now you notice I put most, because not every search or seizure requires a warrant. Most of the time it does. Our US Supreme Court has said that in order for a search to be reasonable, the government should have a warrant based on probable cause. However, since the US Supreme Court has said that, they have carved out many exceptions to it. And the reason they allow for these exceptions to having a warrant is because it's reasonable. These exceptions to that warrant requirement is reasonable. And again, it all comes down to what's in red here. It must be reasonable. In general, in order to be reasonable, there must be a warrant. That's just in general. Not every circumstance requires the police to have a warrant based on probable cause. Most of the time it does, but there are many exceptions to that. And those exceptions are allowed because of the key word, because they are reasonable. So let's define what is a search and what is a seizure. That may sound very rudimentary to you. I know what a search is. Well, when it comes to the Fourth Amendment, and really when it comes to any legal analysis, in addition to the traditional definition of a word, there's also a legal definition of the word. And under the Fourth Amendment, search has a different meaning than it does under the traditional Webster Dictionary definition of search. So a search is, under the Fourth Amendment, is when a government official intrudes into an area of reasonable expectation of privacy. So that definition tells us it must be a government official, and that government official must intrude into an area of reasonable expectation of privacy. So if it's not a government official, then it's not a search under the Fourth Amendment. Keep in mind, these Bill of Rights only protect us from the government. They don't protect us from each other. So we cannot violate each other's constitutional rights. Only the government can violate our constitutional rights. So if you search somebody, or you search into an area of reasonable expectation of privacy, you haven't violated their Fourth Amendment rights, because that's impossible. It must be a government official. Private citizens cannot violate each other's Bill of Rights. So number one, it must be a government official. And number two, that if an official must intrude into an area of reasonable expectation of privacy. Whenever you see this word reasonable in the law, that means it's objective. And what does objective mean? It's the opposite of subjective. Subjective means what is personal and individual to a person. Objective means what society or what a reasonable person would think or feel. So the actual person is irrelevant. It's what would society think. So if there's a question on whether or not the area that was intruded on or searched by the government official, if there's a question on whether the person had a reasonable expectation of privacy, we don't look at that individual And to determine if that individual had an expectation of privacy, we look at, would a reasonable person have an expectation of privacy in that area? So it's an objective standard. So the two things we look for in order for it to be a search is, number one, it must be a government official, and number two, that government official must look into an area of reasonable expectation of privacy. Just a quick example would be a backpack. If you are walking down the street with a see-through backpack and a government official looks at that backpack, is that a search under the Fourth Amendment? Let's break it down. Number one, was it a government official? Yes. Let's go to number two. Is that backpack an area of reasonable expectation of privacy? Well, if the backpack is clear for everybody to see the contents in it, is there a reasonable expectation of privacy then? No, there's not. So that police officer that looks at that clear backpack and from the outside can see what's in there, that's not a search under the Fourth Amendment, because there's no expectation of privacy, because the person is showing the world what's in that bag because it's see-through. Now, if the backpack was just a regular backpack, it was black and it wasn't see-through, and a police officer opens it up and looks through that backpack, now we have a search under the Fourth Amendment, because number one, it was a government official, and number two, did that government official look into an area of reasonable expectation of privacy? So the question becomes, does somebody have a reasonable expectation of privacy in their backpack? And unless that backpack is clear, of course we have privacy in our backpack. So that would be a search. And the Fourth Amendment also protects seizure of property. And seizure of property is when there is some meaningful interference by the government with the individual's possessory interest in the property. For example, if you park in a tow zone and the government, the police tow your car, they've seized your car because there is a meaningful interference by the government with your possessory interest in that property, your car. They've seized it. Now, it was a legal seizure, but it was just the definition of a seizure is when police seize or tow your car. So it's when the government takes possession, so much so that it interferes with your possessory interest in the property. So if the police tow your vehicle, that certainly interferes with your individual possessory interest because you don't have the vehicle anymore. And then finally, there's seizure of the person. And seizure of the person is when a reasonable person would believe that he or she was not free to leave. Here we have that term reasonable again. So we see reasonable, we know it's objective. So if the police stop somebody, whether or not it's a seizure under the Fourth Amendment is going to depend if a reasonable person, not that person that was seized, but whether a reasonable person would feel as though they were not free to leave. Whenever we see reasonable, we know it's an objective standard. So those are the definitions of search, seizure of property, and seizure of the person. And you are going to need to know these definitions for testing purposes. As I stated, the general rule is if the police want to conduct a search, they need a search warrant based on probable cause. Again, not every search. This is just a general rule. And what are the search warrant requirements? Number one, the standard is probable cause. The police need probable cause to believe that objects to be searched for are connected with a crime. And number two, that the objects will be found in the place to be searched. And when you read an affidavit, and we're going to read one in a minute, you will see that that's what the affidavit of a search warrant, and the affidavit is the statement of the officer that they swear to in front of a judge, that the affidavit will state what the objects are to be searched for and where they will be found, whether it's somebody's house or a particular area in the house or somebody's car or somebody's bag. So the police need probable cause to believe that objects they're searching for are connected with the crime and that the objects will be found in the place to be searched. When the police execute a search warrant, there's some strict procedural guidelines. Again, here we have procedural law, and if the government or the police want to enforce this search warrant, then there's procedures that they must follow. Otherwise, the search warrant can be deemed invalid. So the first thing is the judge reviews it for probable cause. And the officer will swear to the truth of the facts. In that affidavit, the judge will read it, and the judge will look for those two things: probable cause to believe that there's objects associated with the crime, that there's probable cause to believe those objects will be found in the area the police are asking to search for. The judge reviews it, and the officer will raise his or her right hand and swear that that's the truth in that affidavit. Then the judge signs the warrant. And the warrant must be served or executed within 10 days. So if the police get the warrant on the 1st of the month, they only have until the 10th to execute that warrant. And the reason being is that the information that the judge is reading and is approving, it will go stale after 10 days. So in general, they give the police 10 days to execute a search warrant, because that information is not going to be good forever. If the police want more than 10 days, a judge has to approve it. They cannot do it on their own. They can apply for an extension of 10 days, and a judge would have to approve it. And it must be served during the day unless approved by a judge. So if the police want to execute a search warrant at night, which most drug raids are at night, a judge must approve that. If a judge does not approve a nighttime warrant, then the police must serve the warrant during the day. And there is a box to check on the warrant for the judge to approve to be served during the nighttime. If that box isn't checked, then the police must serve that warrant during the day. And these are two things that the police must do when they execute the warrant before entering the house. So if there's a search warrant for a house, the police just can't walk right in. They must knock and announce before they go in. Knock, Fall River Police, we have a search warrant, open the door. And they must give a reasonable amount of time for that person to open the door. And what that reasonable amount of time is going to depend on the situation. There's no set time limit. It's going to depend on the situation. So the police knock, announce themselves, wait a reasonable amount of time. If there's no answer, now they can go into the house. If they want to do what's called a no-knock warrant, meaning they want to be able just to bust the door open without knocking and announcing themselves, a judge must approve that as well. And no-knock warrants are usually approved when there's some type of danger involved. If the police can show that if we knock, then that's going to put lives in jeopardy. Or if they can also show that if we knock, then evidence is going to be destroyed. So to get a no-knock warrant, it must be approved by a judge. And here is just a sample arrest warrant. So arrest warrant is the same as a search warrant in that a judge must approve it. It must be executed during the day unless the judge approves otherwise. And in this middle part, you can see where it's affidavit. And this affidavit is the facts. And now the judge reads this, and in the case of an arrest warrant, the judge is looking to see if there's probable cause to believe that person committed a crime. If the judge believes there's probable cause, then the judge will sign it. And this is the officer's signature. So this officer, Ryan Doyle, raised his right hand and swore in front of the judge that these statements are true. The judge found there was probable cause, and they issued an arrest warrant for this person. So there are exceptions to the warrant requirement. The Fourth Amendment requires, again, searches and seizures to be reasonable. Our Supreme Court has said in order to be reasonable, there must be a warrant. Like every rule, there's exceptions to that rule. And these exceptions are allowed because they're reasonable. Because the overall guiding rule is that a search or seizure must be reasonable. According to the Supreme Court, if you have a warrant and probable cause, it's reasonable. However, we're going to allow you not to have a warrant or probable cause as long as what you're doing is reasonable. And that's what these exceptions are. And there's many exceptions, and we're just going to go over a few of them. The first example, or the first exception, is what we call search incident to arrest. And this is when the police search an area where that person was arrested. So if you are arrested, the police have a right to search that area that you have immediate control over. And they can do so without a warrant. And the reason they can do so without a warrant is our Supreme Court in Schimmel versus California said that's reasonable. And in Schimmel versus California, the court ruled that police can search the area within the reach of the person arrested without a warrant. And that includes bags, desks, drawers, and the person themselves. So if somebody is arrested in their office, the police can search that desk that they're sitting at because it's within their reach. And they can do so without a warrant. Now, normally police would need a warrant to search that desk. But under this exception, if that person is arrested sitting at their desk, the search incident to arrest exception allows the police to conduct that search without a warrant. And the reason why is that it allows the prevention of destruction of evidence and to prevent that person from reaching for a weapon. Because the court said if they're arresting somebody, the police don't have time to go get a search warrant because that person could destruct evidence or could reach for a weapon. So because that person is arrested, we're going to allow them to search that area within their immediate control without a warrant. And that's to prevent destruction of evidence and to prevent them from reaching for a weapon. So that's one exception to the warrant requirement for a search. Another is motor vehicle searches. And we have what's called the Carroll Doctrine. And the Carroll Doctrine comes from the case Carroll versus United States. And in that case, that was a long time ago, it was almost 100 years ago. It was in the 1920s when prohibition was in effect and alcohol was outlawed. And the police suspected this person, Carroll, of having alcohol in his vehicle. Excuse me. And the police stopped the vehicle and they searched the vehicle for bottles of alcohol because they had probable cause to believe he had alcohol in the vehicle. And when I say they searched the vehicle, they searched the vehicle. They tore apart the upholstery. They went through that vehicle head to toe and they found the alcohol. Carroll contested the search and said, wait a minute, Supreme Court, you have ruled that police need a search warrant based on probable cause in order to conduct a search. Well, the police, yeah, they had probable cause to search my car, but they didn't have a warrant. So you need to throw out this evidence because it was an illegal search. And the Supreme Court said, sorry for you, but we're going to create an exception to the warrant requirement when it comes to searching motor vehicles. And the rule for under the Carroll Doctrine, the court said police can search a motor vehicle without a warrant as long as they have probable cause to believe evidence or contraband is in the vehicle. So the police still need probable cause, but they don't have to get a warrant. If police have probable cause that there's evidence of a crime or contraband in a vehicle, they can search that vehicle and they can search anywhere in that vehicle where the item may be. And just for a clarification point, the difference between evidence and contraband. Evidence is evidence of a crime. Contraband is anything that's illegal to possess. So evidence of a crime may be a bloody shirt. That's not contraband because it's not illegal to have a bloody shirt. It's just evidence of a crime. Contraband would be illegal drugs because it's illegal to have those drugs. And in theory, most contraband is also evidence too. But not all evidence is contraband. So the police can search anywhere in the vehicle the item may be. So if they're looking for drugs, that vehicle is fair game. They could look anywhere. If they're looking for a stolen TV, now they're going to be limited in where they can search because a stolen TV can only fit in certain areas in a vehicle. So it includes the trunks and containers. If what the police is looking for can fit in the trunk or can fit in any container in the vehicle, they can search that as part of their search of the vehicle without a warrant. And that includes passengers' belongings. So if you're a passenger in a vehicle that gets pulled over by the police and they have probable cause to search the vehicle for drugs, and you have a purse and it's in the vehicle, they can search your purse as well. So that's a quick overview of the Carroll Doctrine that states that police can search a motor vehicle without a warrant as long as they have probable cause to believe that evidence or contraband is within the vehicle. And they can search anywhere in that vehicle that evidence or contraband can be. Another exception, and this is an exception to seizing something without a warrant. And that's what we call the plain view doctrine. And the plain view doctrine states that police may seize an item without a warrant. Remember, the general rule is police need a warrant. But if they're going to seize something that they are lawfully in position to view, and it's immediately apparent to them that it's evidence of contraband, they don't need a warrant. So for example, if the police are legally in your house, let's say they are there because they're taking a report from you. You called the police and you said, my purse was stolen the other night. I want to fill out a report. And the police show up at your house. You invite them in, but you were dumb enough to leave your drugs out for the police to see. The police are lawfully in your house, so they're lawfully in a position and to view the item. Now that item must be immediately apparent to them. That's evidence of contraband. So if it's a big white bag and there's a scale next to it, then that's going to be immediately apparent to them that that's cocaine. So the plain view doctrine says in that situation, the police don't have to leave and get a warrant to seize that cocaine. They can do so without a warrant because it's in their plain view. That's what the plain view doctrine is. Another exception to the search warrant requirement is what we call the plain view doctrine. I'm sorry, it's what we call consent. I was looking at the wrong screen. And consent is if the police do not have a warrant or any level of suspicion, they can always ask. They can always ask you, hey, can I search your bag? And the police do not need any level of suspicion to ask you. They need suspicion to get a warrant. They need suspicion if they're going to search without your consent. But if they have your consent, they don't need any suspicion at all. And the authorized person may give consent, meaning it's your bag, only you can give consent to search the bag. The person sitting next to you can't say, yeah, you can search his or her bag. It's your bag, so you have the authority to give consent. And the police do not have to inform you of your right to refuse, but it is a good idea for them to do. It's encouraged for the police to tell you that you don't have to let us search. And that way there, it shows that when the person gave consent to search, that they did so voluntarily and knowingly because the police told them, you don't have to let us search. So it's not a requirement, but it's a good idea for the police to inform them that you can refuse. And when it comes to searches, we run into problems with co-occupants. So roommates, husband and wife, significant others, those that live together, they're co-occupants, they share a house, an apartment. They can only consent to common areas or areas that they own. So for example, husband and wife. The wife can give consent to search the living room because the living room is a common area. And the wife can give consent to search her bureau because that's her bureau. But the wife could not give consent to search the husband's bureau. Even though they're married, the bureau is the husband's. So she doesn't have authority to give to the police to search the husband's bureau. Only common areas in their own. So any areas they share, if they don't share the bureau, then she can't give consent. So what happens when two people live together and one says, yes, you can search, and the other one says no? The police come knocking, and the wife says, yes, you can search the common areas. You can search the living room and the kitchen. You can search our bedroom. Those are all areas they search. So she has the authority to give consent for the police to search. And the husband's there and says, no, wait a minute. I'm not giving you consent to search. And the rule is that the no wins over the yes. So if two people are on scene and the requirement is that the occupants must be there, and if one says, yes, you can search the common areas, and the other one says, no, you cannot search the common areas, the no wins over the yes, meaning the police cannot search those common areas at that point. The requirement is that person must be there. So if the husband was at work and he called the house and the wife said, yeah, the police are here, I gave them consent to search. He says, put them on the phone, and he tells them, no, you can't search. The police can continue the search under the wife's consent because that person's not there. The person must physically be there in order for that no to trump the yes. And then we have exigent circumstances. And exigent circumstances don't require a warrant. And the reason is because there's some type of emergency going on in that residence or that house or apartment. And there's three exigent circumstances. So if there is, if there's danger of them being harmed, the court says, we're not going to require the police to go get a warrant. That takes a lot of time. If there's some type of harm that could happen to somebody in that house, then the police can go right into that house without a search warrant. Another exigent circumstance is if the police are in hot pursuit of somebody. So if the police are chasing somebody and that person runs into their house, the police don't have to stop. They can chase that person into the house. And the third exigent circumstance is what we call prevention of destruction of evidence. So the police can enter a house without a warrant to prevent somebody from destroying evidence. And these are the three exigent circumstances. It's a very brief overview of these exigent circumstances. And in criminal procedure, we will spend a significant amount of time on exigent circumstances. Now, first, just a quick look at standard of proof. The higher the standard of proof, the more evidence is needed. That's what that means. So we have zero, start off at 0. We have a hunch. Then we have reasonable suspicion, probable cause. And as we start moving over to the right, more evidence is needed to reach this standard of proof. So more evidence is needed in order for there to be probable cause than there is for reasonable suspicion. Preponderance of the evidence is more than probable cause, beyond a reasonable doubt, and then 100% of the evidence. So you can see as we move up the chain here, more evidence is needed. Beyond a reasonable doubt is just under 100%. Reasonable suspicion is what is needed for the police to stop and detain somebody. Probable cause is what is needed for the police to arrest somebody. Preponderance of the evidence is for civil cases, and criminal cases, it's beyond a reasonable doubt. So what happens to the evidence? If the police violate somebody's Fourth Amendment rights, it's excluded from trial in most cases. And that's what we call the exclusionary rule, because we're going to take that evidence. If the police searched your house without a warrant and without probable cause, and they violated your Fourth Amendment rights, there was no exception to the warrant requirement, then any evidence they found is not going to be allowed in court. It's going to be excluded. And that's why it's called the exclusionary rule. There's an exception to that called an inevitable discovery exception, meaning if the police were going to discover that evidence anyway, even though they violated your rights, but if it was inevitable that they were going to discover it, then that evidence can come into play. And now let's talk about the Fifth Amendment for a minute. The Fifth Amendment guarantees double jeopardy, which means you cannot be tried twice for the same crime. Double jeopardy begins when a jury is sworn in. So once a jury is sworn in, now that means you can't be tried again for that crime. And it prevents the same sovereign from endlessly bringing someone to trial. So the federal government and the state government are two different sovereigns. So the federal government can charge you for a crime, and also the state government. They're two different sovereigns. If there's a mistrial, then that's not protected by double jeopardy because you haven't been found not guilty. Meaning there was a mistrial, the jury couldn't come to a decision, or there was something that happened that caused the judge to call a mistrial. What happens is the trial just starts all over again with a new jury. So the Fifth Amendment also protects the right against self-incrimination. It protects against the government forcing anybody to be a witness against themselves. They can't force you to confess to a crime. In Miranda versus Arizona, we had the Miranda rights. And Miranda says that police must inform a suspect they have in custody of their rights before they interrogate that person. And the exclusionary rule applies, meaning if the police violate your Miranda rights, then anything you say can't be used in court. These are our Miranda rights: right to remain silent, anything you say used against you, you have a right to an attorney. If you can't afford an attorney, we'll provide one for you. It's very important is this waiver. The police must ask if you understand each of these rights explained to you. So if they read you these rights, they must ask you if you understand these rights, because if you agree to talk to them, you must understand what you're giving up. Waivers are very important. Miranda only applies for custodial interrogations, meaning that the person must be in custody, must be interrogated. If the person is not in custody, then Miranda doesn't apply. If the person is not being interrogated, then Miranda doesn't apply. So if the police arrest somebody, that doesn't mean they have to read them their Miranda rights. They only have to read them their Miranda rights if they're going to interrogate them. If they're just going to arrest them and put them in a jail cell and not interrogate them, then they don't have to read them Miranda rights. The exception to when the police have to read someone their Miranda rights is what we call the public safety exception. So under the public safety exception, if there is a genuine public safety issue that must be addressed immediately, even though the person's in custody and even though the police are interrogating them, they don't have to read the Miranda, because the court said there's a greater need here. The police officers don't have time to read a Miranda. They need to ask them these questions in order to preserve public safety. So there is an exception to Miranda. If there is a public safety issue, initially the police do not have to read the Miranda, even though the person is in custody and being interrogated. And that brings us to the Sixth Amendment. Again, these are all procedural rights and protections that the Bill of Rights have provided for us. And the Sixth Amendment says we have a right to a speedy trial. We have a right to impartial jury. That's for jail offenses only. So if you commit a crime or an offense that doesn't require jail time, you don't have the right to a jury. You only have a right to a jury if you could do jail time for it. You have the right to confront your witnesses, and you have a right to counsel. Now, there's more Sixth Amendment rights in the book. These are just 4 that I highlighted. And in your homework assignment, I think you're asked to give 4, so you can use these 4, or you can use any of the ones that are in the book. And these are some of the rights that were guaranteed under the Sixth Amendment. Again, procedurally, meaning these are procedures that the government must follow if they're going to impede one of our rights. And we certainly have a right to liberty. And if they're going to impede that by trying to put us in jail, they must follow these procedures. And then lastly, we have the Eighth Amendment. And what does the Eighth Amendment mean? Or what does it protect? The Eighth Amendment protects against cruel and unusual punishment. Comes right out and says it. It forbids cruel and unusual punishment. So if the government is going to put us in jail, or if they're going to punish us, it cannot be cruel and unusual. If they're going to put us, if the government prohibits littering and they want to put you in jail for 5 years for littering, that would violate your Eighth Amendment rights, because that would be cruel and unusual for littering. However, if you're going to commit a robbery and the government wants to put you in jail for 5 years as punishment for robbery, that is not cruel and unusual. So we look at the proportionality of the punishment and how the punishment is applied in order to determine if the punishment violates cruel and unusual punishment under the Eighth Amendment. So that's it for Chapter 4 PowerPoint presentation. You're now free to go ahead and do your homework. Again, please don't do your homework till you watch these videos. I can tell the difference immediately. I can tell the difference when someone has not watched these videos and they try to do their homework. So watch these videos, they're not that long, and then attempt to do your homework. If you have any questions on anything, please send me an email and let me know. And we will see you next time.